Welcome to the last session of the day. Your sugar levels are running high, Jeff tells me, from the ice cream outside. There's only an hour or so until it's wine o'clock, so I hope that we can make this session an enjoyable one, and one in which you all feel free to join in, because it's strategies to obtain information in offshore jurisdictions. And if we listened carefully to David Marchant's speech at the beginning of the day, things are looking pretty terrible, aren't they? Because even the Chief Justice of some of the islands are trying to stop people getting access to information which should be public. Well, is that really what the offshore centres are about? Or is the reality that some of them are as leaky as sieves? And is it right that we're talking about a topic as if it's offshore is all one and the same? Is Switzerland the same as the Bahamas? Is the Bahamas the same as the Seychelles? Is the Cook Islands the same as Samoa? Is New Zealand offshore? Is New Zealand probably the place that you should have your assets? It's a controversial subject in many ways. Lots of people take the view that all offshore is bad. Offshore will not cooperate with law enforcement. Offshore will not help the victims of crime. Maybe that some of you in the room believe that, but let's explore it and let's see where we end up in an hour or so. We've got representatives from Switzerland, Hong Kong, Bahamas, and Jersey. And for some of the less educated people in the room, that's Jersey, old Jersey, not Jersey, New Jersey. It's the little island off France, not the big strip of land near New York. And all of us here would have you believe that we do not live in tax havens. Tax havens are a pejorative word. It's completely wrong. It's two pejorative words, and you should really be using the words well-regulated, low-tax areas. So, let me introduce the panel. On my left is Yves Klein. He's a Swiss lawyer with the firm Monfrini Crettol. He's a partner there. He's a specialist litigator. And has a particular expertise in asset recovery. He gets hugely embarrassed every time I speak with him when I say he is the world's #1 asset recovery lawyer. But he'll tell you at some stage over a cup of coffee, if you can guess past his modest exterior, about the colossal recoveries that he helped win Nigeria in the Abacha litigation. He has acted for Nigeria, he acts for Tunisia, Brazil, Haiti, and is the go-to lawyer in Switzerland for matters involving political corruption. He also handles commercial frauds and the enforcement of judgments and arbitration awards. I anticipate he'd love to simply practice in the area of political corruption and asset recovery, but the reality of that is that those cases have come along very, very rarely, and therefore anybody who tells you that that's all they do isn't telling the truth. So we need to do a broader range of work. A question for you might be, from you to him might be, is Switzerland still to be categorized as a secrecy jurisdiction, or have the Department of Justice beaten Swiss banks into the ground? And if they have beaten Swiss banks into the ground, why is it that it's said that 20% of the world's offshore money is held in Swiss bank accounts? Because it seems to us that Switzerland seems still to be a very, very popular jurisdiction for people to hold their assets. Jeff Lane is a proud Welshman and rugby player, or ex-rugby player. He has lived in Hong Kong for the whole of his legal career, is a partner at the firm Tanner DeWitt. He's a fraud specialist. He does dozens of disclosure orders every year in Hong Kong, and we'll be able perhaps to give an Eastern perspective, because I think we're in almost every time zone. If we could have got someone from the Cook Islands, it would have been great. We'd have gone all the way around the world. Metta MacMillan-Hughes is a Bahamian lawyer at Lennox Paton. She's a litigation partner specializing in insolvency, proceeds of crime, asset recovery, and judgment enforcement. And occasionally, we get lawyers like us get asked questions. What is it about your jurisdictions that make you so well placed to become expert in those topics? But that's what we are. My name is Stephen Baker. I'm an English barrister. I'm also a Jersey advocate, so an offshore lawyer. I specialize in the same sort of work as the rest of the panel, with a particular expertise in political corruption. I've worked with Yves for Nigeria, for Brazil, successfully recovering assets for Brazil, as well as Pakistan, which some of you might be astonished to know really does have a national accountability bureau. Like, I've been in it; it's there, and Kenya. It said Switzerland's a colossal financial centre, as you know, vast wealth held largely through its banks. Hong Kong, another enormous banking centre. Jeff tells me, and I believe him on this, that there are some 750, 800,000 British Virgin Island companies, and that half of those have some connection with Hong Kong. They either hold Chinese businesses through Hong Kong, will be held by a BVI, or there'll be BVI BVI company bank accounts. Vast swathes of real estate in Hong Kong are held through British Virgin Island companies, as with probably much of Miami as well. The Bahamas, its industry, a vast still trusts and corporate service industry. Jersey, a little island 13 miles wide by 7 miles at its broadest, so bigger than Manhattan, for those of you that didn't know, with only 100,000 people on it. My point's going to be that most of the people in Jersey actually think they are more important than Manhattan and bigger than Manhattan. 250 odd billion US dollars on deposit. That's a lot for each citizen, you might think. 250 billion, 300 billion in funds. And then the question that nobody knows the answer to about either the Bahamas or Jersey, what the value of assets held through trust structures held in those jurisdictions. Experts say that it must be trillions of dollars. And when I say it's trillions, I don't really know what a trillion is. And when I say experts, I mean me, and it's a guess. So nobody knows. We're going to look at strategies and to get information offshore, and those strategies might involve the use of criminal process, or they might involve the use of civil process. And which process you use might depend upon whether you're in one of the whether you're in one of the common law jurisdictions or whether you're in a civil law jurisdiction. In the common law jurisdictions, like the three of us on the right, usually you'll be advised that the best route is to use the civil law. And there are a wide range of disclosure orders available and freezing orders available, both before the issue of proceedings, after the issue of proceedings, and after you have won the case, after judgment. So I'm going to shut up very shortly, but I just wanted to read you two slides, which I hope sets out the gist of the approach that the courts in my jurisdiction take to helping people from outside the island. Now, this one is from the Jersey Court of Appeal back in 1996. I really think this was pretty aspirational rather than accurate, but somebody was trying to achieve this in the Court of Appeal. So it says, if if the Royal Court were to adopt the position that it was not willing to lend its aid to courts of other countries by temporarily freezing the assets of defendants sued in those other countries, that, in my judgment, would amount to a serious breach of the duty of comity which courts in different jurisdictions owe to each other. Not only so, but the consequence of such an attitude would be that Jersey would quickly become known as a safe haven for persons wishing to evade liabilities imposed on them by the courts to which they are subject. This is exactly the reputation which any financial centre strives to avoid, and Jersey so far has avoided with success. Although there may be some of you who are practicing law in 1996 who don't accept that that was an accurate representation of Jersey's approach to foreign requests for assistance back then. But it does show what the court was trying to achieve, and it may not be entirely coincidental that it was at about that stage that the international community was really starting to ramp up the pressure on the offshore centres to clean up their acts. I wasn't in Jersey. Actually, I arrived in Jersey in 1996. All good things happening. So, but then let's look at 2012. Jump forward, and this was a case involving an attempt to enforce a Russian judgment from a Moscow court in Jersey, and this is what the deputy bailiff said. The point made by Advocate Baker that in a post-judgment case, the use of the island's financial services to hide assets so as to defeat a judgment creditor is, as a matter of policy, something to be discouraged, is a strong one. The reality is that assets can be and are sometimes moved around the world with speed and secrecy, and the court should endeavour to ensure judgment debtors cannot escape those judgments with impunity. So that's the sort of policy statement you've been coming out of the little island off the coast of France. And I think Hong Kong would say that that reflects their court's approach, and the Bahamas too. And there may be all sorts of questions from us as to whether that's so. So Yves, I've set out what I think the policies of the common law courts are, and also the approach that we would generally advise persons to take, namely using civil process. How does that differ, if at all, from Switzerland?
Well, is it working? Yes. Switzerland is a civil law jurisdiction and has had a tradition of secrecy, which is still in place, as it still remains a crime under Swiss law to breach banking secrecy or attorney-client privilege. However, several type of proceedings allow to lift such banking secrecy. One of the reasons why Switzerland is still very successful in attracting offshore assets, and the assets from non-residents, is that there is still a tradition with the Swiss workforce of respecting banking secrecy. Some jurisdictions have adopted secrecy laws, but do not have a culture of secrecy. I have difficulty myself to gain access to my own medical record because there is such a tradition of secrecy that my medical doctor believes that it's on a need-to-know basis that I should be granted access to my own data. So it just shows where this comes from, and it goes beyond merely the law. So this being said, criminal proceedings, civil proceedings, insolvency proceedings, tax proceedings allow for a lifting of banking secrecy. However, some proceedings are more efficient than others in obtaining the evidence. A request for the production of evidence in support of foreign proceedings through a mechanism called the Hague Convention request, which is mutual assistance in civil matters between two countries, will usually take quite a long time before it is produced, and there is no possibility of interaction. You need to designate very precisely the documents that you want to obtain, and you will not have a discovery order. You will have the few documents that we have precisely designated, and you have to also demonstrate why banking secrecy should be lifted, demonstrate that reasons to obtain evidence is stronger than the protection of privacy of the account holder. So whenever we are approached by someone who says, I need documents in Switzerland, we ask, was a crime committed? And very often the lawyer doesn't really understand why, because under common law, the principles are quite different, and one thinks in terms of either contractual rights or simply basis to obtain evidence. So our standard way of obtaining evidence in Switzerland is to lodge a criminal complaint, demonstrate that there are strong suspicions that acts of money laundering took place in Switzerland, and request to be admitted as plaintiffs in the civil proceedings as a person harmed by the criminal offense, and thus gain access to the evidence that is gathered by the prosecutor investigating the criminal offenses, and this evidence can then circulate in support of other jurisdictions.
So if somebody comes to you, you're looking to see, is there evidence of a crime being committed? Is that right?
Yeah, that's correct.
And if you make a complaint to it's the examining magistrate, is it, or the prosecutor?
It's prosecutors.
Prosecutors now. So you make a complaint to the prosecutors. Do you, hand on heart, have to believe there's a crime that's been committed or may have been?
Well, I want to keep credibility whenever. So I do vet my client's case quite well, and because I know that if I try to push the envelope too far, this is going to harm my future clients. I don't want this to happen. So you need to have some evidence. Again, there is a culture of secrecy, the idea that one will poke into the banking records of someone is something that is adverse to Swiss culture. So you need to have a strong case to show, but there is a very strong willingness of Swiss prosecutors, in particular in the places where a lot of financial crime occurs, to assist victims of crime in order to recover their losses. So they will lend a sympathetic ear. They see themselves as to the service, as being to the service victim, rather than simply merely investigating in view of punishing someone. But very often there is not even a Swiss resident involved. It's a foreign person who proceeded to acts of money laundering in Switzerland, and in most of the cases the banker wasn't good faith. Maybe would have done a better job at identifying the origin of the funds, but not to the level of committing himself an act of money laundering. Okay, understood. Let's look at a case, made-up case, and see how our jurisdictions might, different jurisdictions might deal with it. Jeff, if I can ask you first, a person comes to you, and they say that his or her mother was very wealthy, but she's died. They'd fallen out for some reason or another, but he knows that he was the beneficiary of a trust. He doesn't know where the trust was, he doesn't know what law governs the trust, but he knows that there was a trust because every couple of years a nice chunky sum would come from a bank account into his bank account, and on the rare occasions that he got a birthday or Christmas card from Mum, it said, "Hope you enjoyed the distribution, son, spend it well." All right? And all that they know presently is that the money came from a Hong Kong bank account. How would you approach that? What sort of questions would you be asking?
Well, you'd be looking to establish first whether there's any evidence of wrongdoing. In Hong Kong, and it sounds very much like it is in Switzerland, the usual premise for making an application for any kind of disclosure relief is suspicion of wrongdoing. It doesn't have to be proof of actual wrongdoing. you could be in a position, as you described, where you've got 8 or 9 pieces of a 10-piece jigsaw, and you need the assistance of the court to help you understand the whole picture. And what will happen in that instance, if there is some evidence of wrongdoing or suspicion?
So they say, look, you know, when I told you my mother was wealthy, what I haven't told you is that Grandad invented the zipper. He had the patent on the zipper. So I think the last I heard, there should have been a couple of billion US dollars, and she can't have spent all that on travel and plastic surgery.
Yeah.
So.
Okay. No, in those circumstances, there'd be concerns that perhaps the trustees had misappropriated some monies, or that the bank was, well, we don't know how much money is in the bank account. So to allow us to fill in the missing pieces, you would make an application for a disclosure order. That would be against the bank. Hopefully we know which bank it is in Hong Kong. What you'd expect to get from that would be disclosure from the bank, which would enable you to identify the beneficial owner of the account. I know the Hong Kong banks are not particularly good on risk assessment and such like in the anti-money laundering world, but they are meticulous in the KYC. So they always tick that box of who are the beneficial owners, and they would mine down with the individual concerned, and you'd get a lot of detail as to who has the right to operate the trust. And with the benefit of that information, you'd then obviously be able to contact the trustees and establish whether or not they are doing their job, if the billions are still there.
Is there a banking regulator in Hong Kong, really?
There is a banking regulator in Hong Kong, yes. We've got the Hong Kong Monetary Authority, and they would look into things like that. But at that stage, I mean, if you're just looking at a disclosure order against the bank, I think that would just be the beginning of your journey, because beyond there, you may be looking to take disclosure applications against the trustees themselves.
Right. Let's come to that a bit later. And what about the Bahamas? Does it have a similar process, Metta?
Yes, and one of the things that would be relevant in that application would be the necessity of the provision by the bank of that information, because here's a beneficiary who's received no information whatsoever about the trust, and there is established, although it varies depending on which jurisdiction you're in, there is a right of a beneficiary to at least have basic information about the trust. And in the application that we're dealing with, you would have had absolutely no information. So there's a massive necessity for the court to grant the application that's being made.
Jeff, back to you. I think there's something in America called 1782 application, where you can get disclosure pre-trial and pre-issuing process. But as I understand it, I'm not an American lawyer, and there's lots of them here. The person under suspicion gets notice of the 1782 application, if not before, then pretty shortly thereafter, and has the chance to set it aside. Is there something you can do in Hong Kong if there's a worry that if the account holder finds out about the money, he might move it, or?
Yeah, of course. And I think this is fairly standard in most common law jurisdictions. If you're making an application, first your application is against the bank, which isn't necessarily going to be the wrongdoer. They're merely someone who's become involved in the acts of the wrongdoer. So you're already one level removed away from the bad guys.
But do they have to tell the account holder?
Well, they would normally, as a matter of course, tell the account holder.
Right.
So your provision on going in for the application is obviously going to ask for a gagging order, and that will restrain the bank from disclosing any information about the application or the orders that are granted.
And how long can those last for?
Ordinarily, if you went in on an ex parte basis, there would be a return date, and it would continue up to the return. And the banks in Hong Kong are pretty quick. They turn this information around within a couple of weeks. So hopefully you'll be in a position by then where the disclosure to the account holder would not be a problem. But if you need more time on the return date, you'd simply ask for it.
So assume for the moment that you get your first order, and you've got a gagging order for 2 weeks, and you find out that in fact there's been massive money movements from that account to, let's say, the Seychelles. Would you be able to extend the gagging order with the hope of going to the Seychelles and catching them there?
Yes, you would, and a further provision you'd have in there, you would seal the order, so that when the return date comes back, there's going to be no information in the public court record to say that this bank is being sued by our particular client. Therefore, the ultimate trustees would not actually get notice of the ongoing action. So you then extend the gagging order indefinitely and instruct whoever we have in the Seychelles.
Metta, does Bahamas have an approach?
That's what we would gag, seal, and then get our production order. It would be in that order, because anybody can walk into the court registry in the Bahamas and check the cause list, and the cause list records every action that's commenced by anybody. So, of course, in this case, dear Mama having just died, the bad guys, if they are bad, would immediately have somebody checking the registry to see if there's any actions in the various countries where they know that they have the funds held for a Norwich pharmacal order.
All right, we've discussed it's pretty much the same in my jurisdiction, so I'm not, the test's up there if you want to look at it. Yves, how does your system work?
Again, our civil procedure will work, but will not have the same flexibility and usefulness as common law has. Also because we are using mostly criminal proceedings in those circumstances, so the pressure on the legislator or on the jurisprudence to grant those remedies through civil means is lesser. So nevertheless, the same mechanism work more or less. For example, a prosecutor, when he issues a freeze and production order, for example, may assort his or her order with prohibition from communicating with the client, and may continue this secrecy of the investigation for weeks or even months. Normally what will happen is that the bank, when it receives instructions, will pick up the phone and say, we have received instructions. So the guy gets in the place with, what should we do? And then the prosecutor, if the transfer is small, decides to maintain the gag and allows the transfer to take place. Sometimes it's not the case because it's a large transfer, and the banker does not obtain from the prosecutor the lifting of the gag, and has to begin to make up stories why he cannot. But normally, once a Swiss lawyer is retained, he identifies the causes of this discomfort and approaches the prosecutor and say, you are probably investigating this account.
Because he knows the system.
Yes.
So he knows what's happening.
Yes. So but very often in asset recovery cases, we have discussed with the prosecutor upon lodging the complaint, please do not take steps to freeze the accounts before we have discussed what we are doing in other jurisdictions. We will have to either have coordinated freeze orders so that they all happen more or less at the same time, or if they don't, have the freeze order that are issued in Switzerland to be kept under gag, so that there is a possibility of obtaining the other freeze orders, especially in jurisdiction where there's a time zone difference. In some instances, if your case is strong, you would have access to the evidence even while the gag order is in place, and Hong Kong, and follow the money. And we've done that in some cases.
So you've done that with Jeff?
Yes.
Can you tell us about that? Is it allowed for you to tell us, or is it secret?
No, it's simply you trace the money to Switzerland, you lodge your criminal complaint, you obtain access to the proceedings. The prosecutor orders the freeze of the account and the production of the banking records, and then you analyze the bank record, and you see that the large amount went to Hong Kong. So I give a call to see if it is conflicted or not. And then not give that, because we are litigation firms who specialize in those matters, and tend to be the instructions of Jeff continue, I can negotiate with the prosecutor to make sure that he will not leave the gag. And very often we've had a case where we found that the money was coming back to Switzerland. It was going to Hong Kong accounts and then going to another Swiss account. It was also fraudulent. And all this in also at one point, of course, the prosecutor has to lift the gag, but in the meanwhile you can proceed with secrecy. The other thing, and it's also of interest to journalists, is that our criminal proceedings are and civil proceedings are not accessible to the public. The courtroom hearings are accessible to the public, but the decisions themselves are not accessible to the public. The Court of Appeal decisions are published for scientific purposes with the reduction of the parties' names. So by identifying the lawyer and the facts, very often you know what case it is, but in principle you don't have access to, you don't know that proceedings are taking place against one person or another. So there is not this risk of tipping off through the public access.
In the common law system, if there's a culture of secrecy and banking in Switzerland, there's a culture of secrecy towards the victims of crime in the common law systems. So very often the prosecutors are insistent that if you represent the victim of a crime, they will not tell you anything about the ongoing investigation. And it sounds to me what you're saying that's completely different in Switzerland, and you're actually taking part in the investigation, it seems.
Yes. So not only do we have access, but there's also an expectation from the prosecutor that you are going to assist in either providing forensic analysis of the banking record. They have very good forensic analysis also, but they don't necessarily have the resources to have it done in a matter of days as you need, but very often in those cases. So you will analyze, you will also provide a more general, you are going to be able to put the evidence that is in Switzerland into a more general context, because you know of the generalities of the case when it's jurisdictional, and you are going to be able to demonstrate the relevance and explain the relevance of certain pieces of evidence, and thus request from the prosecutor to take additional steps in one direction or another. You're really an assistant to the prosecution.
Understood. Metta, can I turn to you now? I said that certainly in my jurisdiction, there's a culture of the prosecuting authorities and the police being very secretive towards the victims of crime. It's completely misguided and wrong in law, in my view. But that's what their culture is. But firstly, does the Bahamas have a very active Attorney General or police force?
Yes, they do. They do, and they're very responsive. And actually, they feel that they have all eyes watching them, and so they can be very proactive. I've been on the other side of a proceeds of crime production and restraint order, and I was representing a private Swiss bank who basically stood up for the account holders who had been ordered to produce all their records, and quite often what happens with these production orders is that the banks simply produce. And in this case, the bank opposed the production on the basis that the connection between the alleged crime and the basis for the production order and the basis for the restraint order was far too tenuous. But the Attorney General's office in the Bahamas, they follow instructions to a T, and they come in with all guns blazing. So from that perspective, yeah, it's a very strong attack
So they say.
He can't tell you, it's secret. Jeff, can I turn to you? There's been in just a moment. There's been an English authority where the potential victims of a crime obtained orders against the Metropolitan Police for them to disclose information to them, to allow them to begin to commence civil proceedings. The slides behind you, it was the phone hacking, journalistic scandal's the wrong word, isn't it? Misbehaviour. And the English court, there's too many journalists here for me to say anything detrimental towards them hacking into people's phones. And the court just asked, were the police sufficiently involved in wrongdoing to come within the disclosure principles, and concluded that they were, and ordered the Metropolitan Police to make disclosure. Is there any chance of a Hong Kong court following that, do you think?
Yeah, I think we would. If you've got evidence of involvement in the wrongdoing, and it's not evidence of participation in a voluntary manner. I mean, they're innocently involved in the wrongdoing, and if they have information which would assist the victim to discover exactly what's going on, then they could, of course, be made subject.
And it would seem completely contrary to public policy that if a prosecuting authority, for instance, knew where the proceeds of a theft had gone, didn't tell the victim of the theft, it would be wrong, wouldn't it?
Well, it would, and in Hong Kong, the police are, how would you fairly describe them? They're very keen and very thorough, but they're not particularly bright. They do their very best, and they are occasionally of more assistance than they appreciate. So the police, if they are contacted by a victim of the crime, will actually say, yes, you've obviously been robbed, and they can then go and contact the banks. They issue a letter of non-disclosure where the banks cannot actually release any monies in the account. Now, whilst that acts as a sort of de facto freezing order, it's not particularly helpful to your client because the monies are being frozen so that they can be preserved as the proceeds of crime and then forfeit to the government at a later date. But the police will contact the victim and say, you've got a problem, you need to get a civil injunction to actually go ahead with this. But in terms of what the police are willing to share with us as solicitors, it's very, very little. So the way to approach it there is to go back to the client and have the client call up for regular checkups on it. And they will normally say, well, the money's there or the money's not there. They will seldom actually tell you how much money is there, which can occasionally lead to frustration because there's only $20 left in the account of the 2 millionth of a cent there, and you've got to spend a bit of money to actually get the orders anyway. But the police are very useful if it's a Friday night and you've just had a call from Europe and someone said, my God, this money has come across, and you need to have someone capable of freezing the account. You're not necessarily going to be able to get all your evidence available to take an injunction on the weekend, but there's always a night watchman or something at the bank who will take the call, and once they've got notice of it, particularly from the police, they're at risk themselves, so that the accounts will be de facto frozen by the police. Understood.
Let's just go back to the beneficiary of the trust example. And just a question, Jeff. What does the H in HSBC stand for?
Seriously?
No, seriously.
Hong Kong.
Hong Kong, okay. So it turns out the bank account was at HSBC, and just oddly, Jeff, they don't have the money laundering information. So it doesn't, when they get the HSBC account information, it doesn't say that the beneficial owner is Mr. Z of Beijing. It doesn't say that. What it says is that all you have is the fact that the account was held in the name of a Hong Kong company. What are you going to be able to do? What's your registry going to tell you? What's the company registry going to tell you?
Just very basic information, who the directors are, who the shareholders are, where the registered office is, and very little else.
Will that be the real shareholder, or will that be some corporate service provider, almost inevitably?
Often it'll be a corporate service provider. But if you then need to go to the route of that, you can take your disclosure order against the corporate service provider.
So if you have the good fortune, this would never happen, I guess, but if it was a Hong Kong company with a Hong Kong corporate service provider, would you go through the whole Norwich Pharmacal process again on the service provider?
Absolutely, yes.
Understood. And Metta, what about Bahamas?
Very similar to what Jeff just said for companies that are incorporated under the Companies 1992 Act. But international business companies, it's a little less. You will not get the members of the company. But other than that, and you won't get any accounts for the company, but they are required on, both types of companies to have the accounts at the registered office.
And you have a company's registrar, presumably,
Yes, yes.
or similar. What information does, as far as you know, does your registrar have as to who the shareholders are, the actual shareholders, not nominees?
I'm not sure that
no.
they.
No. Jeff, do you know what the Hong Kong registry has in terms of?
Yeah, all the Hong Kong registry has is what they're given by the company.
Yeah.
So they don't actually mine down to work out who the beneficiary is.
So is that like the English company's house was, with garbage in, garbage out, Mickey Mouse?
Exactly.
Right. Okay. Understood. Yves, so it turns out to be a Swiss company.
Well, this is odd because normally you don't use a Swiss company to own a Swiss bank account.
Of course.
When you're talking about offshore activity.
No,
But it happens.
Yeah.
So if it's a corporation, you will, or let me again, if it's a limited liability corporation, you will know who the shareholders are. They are registered in the Register of Commerce as well as the directors. If it's a corporation, the names of the shareholders will remain anonymous, but you will know who the directors of the company have been. If the shares are registered shares, then you will have a ledger at the headquarters of the company registering the names of the shareholders. If there are bearer shares, there is now an obligation for the board of directors to request who the beneficial owner of the bearer shares is. But this information is exclusively in the hands of the board of directors, and so it needs to be produced either through criminal proceedings again or through the less efficient civil proceeding.
So if I understanding exactly what you're saying, nobody's going to use a Swiss company with a Swiss bank account. That's crazy, right? It does happen.
It does happen. It does happen.
They're not very well advised, are they, if they do that?
No, in furtherance of a fraud, for example,
yes.
We have several occurrences of, for example, Robert Allen Stanford had set up a Swiss company because it was somehow also giving him a more international image, and we have other cases where in Ponzi schemes the fraudsters set up Swiss companies which have little substance but are used to show that that it's a well-regulated group and has chosen a very respectable jurisdiction. Understood. If I could just briefly deal with the Jersey position. There are very few Jersey companies. There's something like 40,000 of them, about that, whereas there's 800,000, 750,000 BVI companies. And the reason for that is that for about the last 20 years or more, the Jersey registrar must be told the beneficial owner on pain of I think it's 2-year prison sentence. So if you look at go and check the Jersey registry, you won't find the shareholders. They'll all have nominee shareholders listed, but the shareholder or the incorporation nation has to tell the registrar who the beneficial owner is. And these days, it's not good enough to say that the beneficial owner is a trustee. They will want to know who the beneficiaries of the trust are, which makes it fairly obvious why nobody would incorporate a Jersey company to try and hide something if they were properly advised. I've got a couple of general questions for everybody. Yves, do you think the drive for public registries with real beneficial owners listed in it is a positive thing for asset recovery lawyers? Well, I must say that I'm a bit worried about the increased tendency for those registers to be public, because what we find in our investigations is that fraudsters or family members of public officials who, of officials tend to be relatively truthful in the disclosure of their identities to their bankers, or their trusted professional service providers, so that you find a wealth of information when you get access to those cases. What also happens is that the production orders of a Swiss prosecutor, for example, is very often, when the case is large, the production order is often drafted in a way such as to state any account of which such and such persons are the designated beneficial owners of. So the exactitude of this information is very important, because it provides information and allows a certain account to fall in the net. The other thing is that when the case gets media attention, Swiss banks tend to report those accounts to the money laundering reporting authorities of Switzerland, and very rarely before there is a media attention, but once once there is media attention, you see a wave of such reports, and this is not based on the thorough analysis that the bankers have conducted regarding the origin of the funds, because if they had conducted this analysis from the start, they would have either not accepted the monies or reported it. So the mere fact of seeing the name of the beneficial owner in their form in the banking records will trigger those reports. If the company that holds the account is registered in a jurisdiction where beneficial ownership must be disclosed, fraudsters and family members of corporate officials will stop to, will certainly not provide the information that they would give to their bankers or
so you fear more musicians.
So either they will move, as people get away from those, they will move away to other jurisdictions where such public registers do not exist, or even worse, from our perspective, they will put an additional layer of opacity by using a straw man. And once you have a straw man designated as a beneficial owner of a bank account, many of the remedies that you use on those large investigations do not work, because the name of the associated persons will not pop up. So it will be much more difficult. You will have to trace transfers to and from the account and find it, I would not say by chance, but it will make things much more difficult. So even though from a political point of view, the use of public registers of beneficial ownership will deter, or at least make more costly, the use of those offshore structures, I'm not sure that it's a really good idea from our perspective. And also, the bank, for the moment, has a duty to identify who the beneficial owner is, and it is a crime to wrongly designate the beneficial owner, or even to have a poor due diligence regarding this specific information. Once there is an official record stating who the beneficial owner is, the likelihood that bankers and compliance officers will relax and say, well, if this is the official beneficial owner, I don't need to investigate that matter very much, is I would say, much higher than it is today. So there is, from my perspective, a risk that not necessarily the petty criminals, but more sophisticated fraudsters or bribe takers will make this more difficult, and will make also the due diligence conducted by bank less efficient. And I'm not saying that it is efficient now.
Metta, what are your thoughts?
I was thinking about the fact that we can, I'm just wondering the categories in Switzerland when you can actually get information from banks in civil proceedings, and I was thinking about the ease with which we can ask the banks to produce information in aid of civil proceedings. I do a lot of matrimonial and divorce asset recovery, and if you have a difficult spouse, you can simply go in ex parte and say to the judge, we need all his bank accounts and we need his savings accounts, and here's a couple of deposits, so we know he's got them and he's not producing, and you go in ex parte and you get the order and the bank produces everything. So I'm just wondering, what do poor dependent spouses do in Switzerland?
But the right of a spouse to be informed about the other spouse's assets also exists in Switzerland, so it's one of the exceptions to banking secrecy. However, banks, in order to cover themselves, especially when you are talking not so much of a Swiss couple, but maybe a couple who is abroad, banks will request a court order to produce the documents, and in those circumstances, you cannot get it ex parte. Both the bank and the other spouse are put on notice. There are issues also regarding the length of service, because we have to service through the Hague Convention procedure, so it takes a month when it doesn't take years. And the other spouse can oppose and appeal, so it takes time, but the information is preserved and is ultimately accessible to the other spouse. Sometimes you can gain earlier access to the information by, instead of requesting, or in addition to requesting the banking records, to examine the account manager as a witness. So you will obtain information directly. You will not get the minutes of examination, because those will be kept until the end of the proceedings, but you will gain the intelligence necessary to pursue assets abroad. So it is one of the exceptions. The other one is in the case of estate, in inheritance, any here has the right to obtain information from the bank regarding, just again, if it's a non-disputed asset, the bank will provide information voluntarily. If it is in the context of a dispute, a disputed inheritance, then the court order will be necessary.
Let's move forward through the process, because time's passing, and I want to get on to some recent disclosure decisions that have been made in England and ask your views on whether your jurisdictions might follow them. For the common law jurisdictions, once proceedings have been issued, is it right that there are methods to obtain witness evidence and documents from your financial institutions, common law? Yeah.
Yeah, yes, of course. The Norwich Farming Bill is also common law based, but we also have statutory remedies in Hong Kong under the evidence ordinance, which enables parties to litigation to request documents from banks. Not actually to request documents, it's actually an application to allow you to go to the bank and inspect and take copies of documents which are relevant to matters in the proceedings. It follows what used to be known as the banker's books order in the United Kingdom. Obviously, the banks don't want sort of large solicitors running around messing with their computers, so they tend to be treated in the same way as you would a disclosure order. So even though the order actually says allow access to copy and inspect, the bank will normally turn up and tell you first what the balance of the account is, then they produce the account opening documents and the account statements, and once you've analysed those, you go back to a specific transaction disclosure.
Yves, I'll come back to you on this topic if we've got time, because things are moving on. Things go well, and we win the case, and we've got a judgment in our favour, and proceedings have been issued outside our jurisdictions. So let's say there's proceedings in Miami, and there's a judgment in the plaintiff's favour in Miami. Now, in my system, there would be no problem in obtaining an injunction over assets in Jersey to help the American courts enforce the judgment. Is that the same in the Bahamas?
We would need to have a substantive cause of action in the Bahamas. Even if we didn't intend to proceed on it, you know, there's another action elsewhere, we would still have to have a substantive cause of action in the Bahamas in order to get an injunction and a disclosure order in aid of that injunction.
Thanks. And Jeff, just in a yes or no, can you get the injunction in support in Hong Kong?
Yes, you can now.
That wasn't yes or no, that was...
Yes.
Okay, good. Now, one of the crucial parts of these freezing orders are the disclosure orders in order to police them. And you would expect in the common law system for a disclosure order to be made that the defendant discloses all of his assets to you. Now, sometimes they do and sometimes they do, but again, yes or no both. Can you get that type of order in your jurisdictions?
Absolutely, yes, and you can get an order to sign.
No, that's fine. And is it yes with you, Jeff, as well?
It is yes.
All right. Now, sometimes people won't cooperate. Now, I want to just explore for the moment what the chances are post-judgment of getting an order from a third party to disclose information about assets. And I think Stephen Phillipson has been involved in a case where that happened. Stephen, I wonder whether you might tell us how you managed to get some disclosure out of a third party.
Both of the cases that we dealt with this year involved the implementation of what was called Anton Pillar orders, but are now called search orders, because we have always found that as people tend to keep all their information on laptops and iPhones, etc., the quicker you can actually get hold of them, the more access you have to current information. So really on the first case, what happened was the defendant was avoiding, we got judgments, etc., still avoiding, and then we decided to get orders against, first of all, the banks that were relevant, and secondly, the defendant's relative who was holding information and obviously doing nothing more than that, and therefore wasn't accountable. Now, what happened was that the banks disclosed the information that this third party, the relative, had, and so you expected that the third party would disclose exactly the same information. But obviously blood is thicker than water, and the third party, the relative, did not disclose all the information, which clearly we had, because there were relevant emails, relevant bank statements, which he had, but he didn't disclose. We also established that he falsely understated the assets and backdated the assets of the defendant. So we felt we had enough grounds to apply for the search order, whereby we were entitled to go into his premises or where the goods, where his financial information was located. We went in without notice to him, except when we arrived on the door, and we took away his various phones, his various iPads, and various other matters where he held various financial information on behalf of the defendant. The second case is when we, following the judgment, we had a court enforcement officer, known previously as a sheriff or a court bailiff, go in. These days they are incredibly efficient and they take absolutely everything. And included in that everything were the person's laptops and iPhones, etc., and we applied without notice to the court for an order that we had access to those phones and to the various items where financial information was collated. So we, in those two cases, managed to get access to current financial information, which was obviously very crucial and very important and very helpful.
Okay, thanks, Steve. Now, Jeff, can you tell me, as a matter of policy, is there any chance of Hong Kong following that type of lead?
Well, there's no reason why they shouldn't. We've got very much the same rules of the High Court as operate in the United Kingdom. But it's a form of relief which has been hiding in plain view. That's in there in Order 29, Rules 7 through to about 13. And it's a fantastic development, so well done, Stephen.
And Metta, what about the Bahamas? Do you think you might persuade your court to follow that?
The Anton Pillar.
Well, on a third party as opposed to on the defendant.
I think that they will be persuaded by the other common law countries and the way that they're heading. Yes.
Well, there's no chance. Jack Blum loves this power of as we're calling them at the moment, the common law countries to have a civil search warrant. What's the chance of getting one in the States, Jack? Yeah. Right. So I think we need to be careful when separating the common law from the civil law. But Yves, I think it's right that it's been heard of in Switzerland. That sort of thing.
It's unheard of, but Stéphane Bonifaci and I are working on the case where he's obtained evidence through civil proceedings, and I'm wondering now whether it is that impossible.
Okay, well, Stéphane, can you tell us a bit about what order you got and which jurisdiction you're from?
Well, I think, bank secrecy is very strong in France when it comes to civil proceedings, and I think it's important to say as well that one of the big differences between the civil law system and the common law system is that there's no contempt of court mechanism. So if someone doesn't follow what an order was, an order, well, he won't go to jail. That will never happen. So, you have to find other ways, and indeed, like Stephen is doing, you need to get hold of the computers. You can file an ex parte application if you have a good case, and including against third parties, and see what's in there. What I would like to know, as far as Stephen is concerned, is what I do. I give a list of keywords because there's a limit to what you can go through. Would that be the same, or can you go and check every information that you find in a laptop, in a phone? Everything is available, or is it limited to keywords?
Is that the search order is carried out by an independent solicitor to ensure, and he will get the documentation. There is then invariably a sensible dialogue between all three parties as to what we can have access to. And if, as is sometimes the case, the defendant is not sensible, the court will make the order providing that the reasonable information is supplied.
Can we just move on from there briefly? We've been approaching this as if in the common law, go the civil procedure route. That's what you must do. And in Switzerland, civil law, go the criminal route if you can. Now, Jeff, can I just ask you this? Are there circumstances, there obviously are circumstances when in Hong Kong it's going to be better to go to the criminal authorities, but what I'd like to ask you is, are there particular ways in which you can use the criminal law to help a civil litigant? So for instance, say they haven't got that much money and they're worried about an undertaking in damages on an injunction. What sort of thing would you be thinking about then?
Well, again, as we touched on earlier, what we'd be looking to do is get the police to issue a letter of no consent, so that the banks would be restrained effectively from disposing of the monies pending forfeiture as proceeds of crime.
So what's a letter of no consent?
It's a letter written by the banks, written by the police to the banks, which say these monies are the proceeds of fraud. As such, they are liable to be confiscated by the government. Therefore, you shall not release any money from the account until you hear further from the police.
But surely that needs to be reviewed by a court pretty quickly.
Not reviewed by the court. It's just simply within the discretion and the jurisdiction of the police. They are meant to review it more regularly than they often do. Often when these things are made, they just sit on the file and they don't move. We did have an incident a while ago. Yves and I were acting on behalf of a Swiss client who had such a letter issued against accounts in Hong Kong and had been there for something like 13 months. Monies were inactive during this period. It was a period of economic turmoil, so the monies were fluctuating in value considerably. But in the time between the letter being issued and our making a request for it to be removed, the injunctions underlying the complaints which led to the effective freezing of the account have been removed. There have been some very, very critical comments made to the parties that applied for those injunctions, and we made that information available to the police. We reminded them that they should actually be reviewing these letters of no consent at least once a month, and we threatened them that if they didn't actually release the account the next time they came to review it, in light of the additional information, we would judicial review them, and begrudgingly they give the money back.
And Yves, you and I were involved in a case where there's been such a no consent for well over a decade, right? Yeah. In my jurisdiction, the no consent order is referred to colloquially as a minty freeze, and there are two terrible things about that. One is it names the policeman who first used them minty, and it uses the word freeze, which has the unfortunate connotation of it sounding as if there's a court order, when in fact it's not. It's just the word of a policeman saying you can move it if you want, but you're run at risk of being prosecuted for money laundering, and it's 14 years imprisonment if you get it wrong, which of course has the effect of a freezing order by injunction. And we've been waiting for years for somebody to challenge this as in breach of human rights and the like. And Tommy Suarto's son challenged the order in Guernsey. And at first instance, a Guernsey judge said that there had to be a court order to control this. And because there hadn't been a court order, I think it's a decade plus again, said that the money could be moved. That was appealed to the Court of Appeal of Guernsey, and they overturned that decision and said the wording of the law is if you move money knowing or suspecting that it's the proceeds of crime, then you run the risk of being prosecuted for money laundering. That's a commercial decision for you to make. Nothing that it is perfectly proper for the police to put you on notice of it. And I think a lot of us thought that that would go to the Privy Council as a point of constitutional interest, and the Privy Council refused to hear the appeal. So in I think the common law jurisdictions, you can get an awful long way with a well-written letter from the police. In fact, you can do it yourself. You just write to the bank saying you'll be fully aware of your criminal and regulatory responsibilities. These are the proceeds of the crime. This is why I say the proceeds of the crime. If you move them, you'll be committing the offence of X, Y, Z. Have you made a suspicious activity report? If not, you should have done something. It's a really powerful tool. So I don't want anybody to leave the room thinking that it's a simple decision, civil procedure route for criminal, for common lawyers, criminal for the civil law countries. We've got a range of other topics which we could talk to you about and talk with you about, and we've jumped things. But has anybody got any questions? Is anybody convinced now that the offshore jurisdictions are more effective than some of the onshore jurisdictions? Nobody's convinced of that. Jack, you must be convinced. We can get a civil search order. The leader of the Tax Justice Network must change his position.
Tax structure.
Well, they know that they will on the receipt of a tax information exchange agreement request, then they will. So those documents would be disclosed. As you know, we need some jurisdictions somewhere in the world needs their Supreme Court to deal with the enforceability of foreign tax judgments. I'm with you on that. But that's no different offshore than in your place.
Yeah. Can I add to that?
Point well made, and I quite agree.
Yeah. If I can add to that, we've got an instance ongoing in Hong Kong where a company in the UK has been liquidated because of its inability to pay certain amounts of VAT, and there's been a huge tax avoidance going on. But the liquidator has now brought an action in Hong Kong to get disclosure to identify assets which may then be available in the liquidation. And the courts in Hong Kong have looked at that, and they've acknowledged that ultimately this information is going to be in support of enforcement of a taxation judgment, which normally would not be allowed, but they're looking instead at the liquidator's duties to investigate and identify assets, and they've allowed the disclosure to facilitate that function.
We were instructed by a liquidator in the United Kingdom, and it was a tax problem. And we advised them that they should seek to enforce the judgment of the Foreign Revenue, but that we were obviously going to lose at first instance and lose at the Court of Appeal, but that we thought the Privy Council, which is our highest court, might take the appeal, but they didn't have ready access to cash to pay the lawyers to take it through the appeal system. And another way towards that is to try and get the Revenue and Customs to back the liquidator and pay the fees on the speculation that needs to be tried.
But were there no creditors other than the tax? Because
no, there wasn't in this one, because we have the farcical situation where, if I get this wrong, people will shout at me, that if you have some other creditors, they'll enforce the judgment. Yeah. It's only if it's a pure tax judgment that they won't enforce it.
Switzerland does not cooperate in the enforcement of foreign tax judgments. However, if the tax debtor is put into insolvency, the liquidator can obtain recognition of the insolvency proceedings and bring any claim through a Swiss ancillary proceeding in Switzerland. So there are ways to go around those obstacles and those walls.
Any more questions?
I've got a question.
Okay.
What about the liquidator's costs? Could the liquidator's costs have been sufficiently significant to justify them recouping the assets from overseas, and then the balance would go to the tax?
I don't know. We've got liquidators in here, haven't we? Does anybody know the answer to that? I'm not going to pick on any liquidator, even though I can see a few.
Not shy.
There you go. That's something for us to go home and look up, isn't it? Any more questions?
In the Bahamas, you can.
In Hong Kong, there are very limited documents available. You'll have the originating process, which will be a writ, originating summons or similar, which will set out the very basic relief that the parties are looking to obtain. Beyond that, you'd actually have to be a party to the litigation to actually get access to the court file.
In my jurisdiction, there's a problem with this, because there is a history of keeping the transcripts and the like secret, when, in my view, they should plainly be available to the public. So that's a matter which needs to be addressed. I think the court will order that they have to be public. It's just a case hasn't cropped up where anybody's been sufficiently bothered to get the transcripts to actually pay the money to argue it. But I think the court will come to the position that, you know, justice has got to be public. It's not. Yeah. Yeah, well, you can see the pleadings.
In the Bahamas, you don't have to bang on any desks. You just go and you do a causeless search in the name of the parties, and one or other are going to come up, and you will find your action and your action number, and then you either go to the criminal section of the registry, or the civil section, or the D&M section, and you ask to see the file, and you get to see everything on the file. You get to see every document that's been filed. You even get to look at the judge's notes of the hearings, but you do not get a copy of anything other than the originating process and an order that's been made in the proceedings. You don't get to copy the affidavit evidence, but there's nothing to stop you making a note of what you can certainly review the file, yeah. Yes.
Let me just pick you up on that,
Right.
Metta. I anticipate that you're talking about a case where there's a dispute between one person and another, so a victim of a fraud sues a fraudster or a bank for dishonest assistance, then you would expect that to be available. Are there circumstances where, for instance, a wealthy family are arguing about where some trust assets should be paid, where
It's been sealed. If it's been sealed, it will not be available in the registry.
So there's a rule. There's a rule which comes out of the English High Court, isn't there? That if families are in a dispute with a trustee as to how trust assets might be managed, how they might be best invested, that will be all in secret, wouldn't it? Yeah. Does that deal with your point, Philip? So there's another Jersey lawyer here, Philip Sinnell, who's shaking his head at what I'm saying, so I want to make sure he has his say. My understanding of the Jersey law is that in a contentious case, you get access to the pleadings once the defence is served, so you can't go in and see the originating process until there's a response to it. Then you can. Is that right, Philip?
Continue.
You can't get affidavits.
You didn't have the mic.
Yeah, I have done it, probably by accident rather than, or well, no, they get very difficult. They don't have a real policy on it, so it's still very difficult at the moment.
But
Yeah.
Philip, it's a fair point that Philip makes, that there is a tendency to the court towards secrecy, and it's the court administration, obviously under the direction of the judge, but it's the court administration which has got this hangover of secrecy, and that's something which will have to be challenged, because of course you should be able to turn up at the court and look at the lists publicly available, but to look at the pleadings and the evidence once people have started proceedings, it should be available. And I think that'll change. Philip needs to find somebody who'll put his head over the parapet to argue it.
Simply that you'd have access to originating process, but for anything else you'd actually have to be a party. The originating process, they'd give you a copy of that. If there's a judgment, the judgments are normally published, but you would not have access to the general pleadings. You would not have access to any affidavit evidence or witness statements filed.
In Switzerland, you will, in principle, get access to nothing. Now, the only exception are at the Federal Criminal Court. The judgments are public. In general, the Court of Appeals, it varies from one canton to another, but in general, you will find some, if you know your case quite well, if you know who was the attorney representing one of the parties, you can find your way, and even though the names of the parties are redacted, you will find some useful information in the Court of Appeal.
So can I ask you a question? Does it follow that when you're instructed as an investigator with a matter offshore, trying to find out what's on the court record is one of the things that you think would be helpful? Yeah, and is that a standard approach you would make? And public registries as well, obviously important. And in Casewell, you're from Minsk Group. Can I just ask you this? We've heard what this gentleman says about the sort of steps he would take in relation to dealing with registries and the like. I anticipate that's the sort of thing you would do. And he made, I thought, the very interesting comment that the personalities, the personalities of the people are important. How does that feature in your thinking?
Thanks. I mean, there's a human aspect to everything, right? The manner in which you ask and the level of detail that maybe the custodian of that information is aware of. I think the pitfall within trying to exploit someone's naivety is if you're in legal proceedings and you're going to obtain something which you're not entitled to, then you're potentially leaving yourself open to risk in the future. However, knowing that information and using it as intelligence to maybe work out how you can obtain the information by using people like yourself is probably an important consideration. Well, let's
take a specific example. The lawyers find out that the corrupt politician or the criminal has got a big boat and it's registered in the Isle of Man. The Isle of Man, you can't get public access to the Isle of Man registry. What sort of things is it that you're bringing to the party in terms of that asset, connecting it to the criminal?
Well, probably the first dance step that we'd probably do is a social media research, for example. Obviously, people like to publicly demonstrate their wealth, and even if the corrupt official is shrewd enough not to have been posting pictures online, maybe his children are, for example, you can obviously get quite a lot of detail from the metadata that sits behind that. And it's like the jigsaw. I mean, as we heard to start with, you've got 8 pieces of a 10-piece jigsaw. If you can start building up that picture and working with lawyers like yourselves, you can work out a legal and investigative strategy that can find the final 2 pieces correctly, so you can use it in an actionable way.
And is that your experience too? Okay, thank you both very much. Any more questions? I can tell you that the case study that we used came from a question Yves was asked at the drinks reception, or I was asked, and I said you need to talk to Yves. All right. Well, thank you all very much for your attention.
Oh.
I moved to the
Oh, yes.
side of the
Okay, that's